knowledgeable about different things and leave a legacy for our family and our children. Amen. So before we get started with our guest speaker, we want to bring up Miss Samantha to move us further along in the program.
All right, good morning, Cover Girls. Good morning. Are y'all excited about learning more about how we can protect our assets? I know I really am. So right now, it is my pleasure to introduce one of my favorite law professionals, as well as one of my near and dear friends, ReAzalia Allen, who is the Attorney Southern Belle. She's a Shreveport, Louisiana native who has all of the degrees from different places, but my favorite of all is from LSU. She received her undergraduate degrees there, as well as her law degree from LSU. She's currently an adjunct professor at the Southern University as well. She just loves Baton Rouge, and I'm just thankful that she's here with us today to be able to share her knowledge and share her passion with us so that she can help us make sure that we're covered. She was also recently acknowledged as one of the top 40 young lawyers on the rise in the nation via the American Bar Association. So please help me welcome the Attorney Southern Belle, ReAzalia Allen.
Good morning. Thanks for coming today, and I hope that you guys gained some information, those of you who are watching online and those of you who are present with us today. So I'm going to give a 30-minute presentation, and then I'm going to answer any questions that you have. If you have questions online, feel free to put those in the chat, and we'll try to answer as many as we can. So let's get started. We're going to talk about life insurance, wills, and trademarks. How many of you all have life insurance right now? All right. Do you know what type of policy that you have? Do you have a term life, whole life, universal life? Anybody have return of premiums? So I'm going to go into that as well. The next asset that we're going to talk about is we're going to talk about wills and advance directives. That's going to be more of my estate planning piece, but all of this goes into estate planning. And then the next portion that we'll talk about, we're going to talk about trademarks. How many entrepreneurs do I have out there? Do you have businesses and LLCs? Okay, so we're going to talk about intellectual property as well. So let's hop right to it. Let's talk about life insurance and why you need life insurance. Life insurance is for you to leave a legacy to your family in the event of your demise. So some of you all said you had term life insurance, and some of you all said you had whole life insurance. Well, there are different types of life insurance policies. You can have a return of premium, you can have term life, or you can have permanent life, which is also known as whole life. So let's talk about return of premium. Return of premium life insurance is where you would have a term limit, but you would be paying these premiums over those terms, that term, maybe it's 30 years. So in the event that you don't die in 30 years, you would get all of that money that you paid toward that premium back. But the end result is that you would not have life insurance anymore. Term life is just what it is. You could have a 10-year term policy or a 30-year term policy. And if you don't expire within that term, you would then have to renew, and sometimes they change that over to a whole life policy. Then you have a whole life policy, or what we would like to call universal life insurance. So universal, that's where you can, it's almost like it's a savings scheme and an investment scheme. And I personally have term life insurance, not term life, permanent life insurance. So when you have the universal policy, what we have is you have an investment plan, you can borrow from it, but then you still have an assurance of a full policy benefit to be able to cover anything that happens to you if you die. So like, let's say what types of things can be covered. Things that can be covered would be like your mortgage. Let's say you may have some loans out there that your heirs would need to pay. Well, life insurance will cover that. Now, the thing about life insurance that you all have to be cognizant of is that you must name a beneficiary. That beneficiary should be someone who you can trust to take care of your estate in the event of your demise. So be careful of the people that you have in your camp. That's a life lesson. And so another reason why we need to have life insurance is that we're living in an age where there are GoFundMes and we're selling places to pay for funeral costs, when in actuality we can avoid doing that by paying maybe $10 a month or $100 a month for a life insurance policy, or even for a burial policy. It is good to have a plan A, plan B, and a plan C, especially when you're talking about yourself and protecting your assets. That is something that everyone should consider doing. So we don't want to be selling GoFundMe plays or having a fundraiser to pay for funeral costs, and then you can't bury the person within 2 weeks of time. It's taking a long time, or then you have to do other options. So that's why it's good to have a plan. So I feel that having life insurance is actually one of the greatest assets and investment pieces that you can have. And I'll get into why I feel that way in just a second. All right, so now let's talk about wills and advance directives. Why you need a plan of action. How many of you all have a will in place? Okay. So not many of us have a will in place. We need to have wills in place, and we need to have certain advance directives in place for others to be able to act on our behalf in the event that we're not able to act for ourselves. So the inevitable is bound to happen. So that's why you need to have these things in place. And also, just to keeping it real, can I keep it real? It avoids drama with your family. Just having something in writing for the way that you want it, how you want it, it would cut down on so much court costs, attorney's fees, and the drama and the family fallouts. So that's why you need to have something in writing. Even if you have to write it on a piece of paper, sign it, and date it, at least it's still a valid will, and that's what we call an holographic will, which I'll go over that as well. So like I said, it allows you to leave a legacy in the manner in which you desire regarding your assets. I mean, some of you all are entrepreneurs. You might want to leave your business to someone, or the assets of your business to someone. Some of you all have properties. You might want to leave those to certain people. You know, and a will, in my opinion, it is a safeguard because you can leave it to who you want, and you don't necessarily have to follow the rules of the law in case you don't have a will. So tools for planning. This is what I tell my clients who come to me for will drafting and estate planning. One tool that I left out that everyone needs to have is a financial advisor. Please invest in a financial advisor, because financial advisors can also get you to these tools as well. They may not can draft them and give you advice on them, but they can refer you to an attorney like myself who would be able to draft these documents. So you have a general power of attorney, you have a healthcare power of attorney, a living will, last will and testament, and in Louisiana, while it's not unknown, it's not really done, unless you're like, Bill Gates or someone, trust. So let's talk about general power of attorney or healthcare power of attorney. Does anyone know what a general power of attorney is, or a healthcare power of attorney? Okay, well, let's get right to it. So a general power of attorney, in Louisiana, we call this the law of mandatory, principal, and agent. So a general power of attorney is basically a document that gives someone the power of attorney to act over your business affairs in the event that you're unable to act. If you're military, you may know that you have to have certain power of attorneys in place, like if you get deployed. In the context of buying a house, you may have to have a power of attorney in place. If you're not able to attend the closing, someone else can sign on your behalf. Well, it's the same thing when dealing with your life in general. You need someone who can act on your behalf in the event that you're not able to act on your own behalf. Let's say you're in the hospital for a few days and or maybe a month or so. COVID was a real thing. Some people were not able to get out of the hospital until like a month or two. So who was handling their affairs? If they didn't have a general power of attorney, it was probably next of kin. But when you do have a general power of attorney, you can give your mom, your best friend, or anyone, this is while you are living, to act on your behalf. They can attend hearings for you, lawsuits. They can answer lawsuits for you. They can open your mail. They can deal with the banks on your behalf. That's why this is really something important that everybody should have in place right now at this moment. For example, for me, I have power of attorney of some of my relatives. So if something happens to them while they're living and they're just not unable to act, I'll be able to make those decisions for them. And it's like, because they gave me the power of attorney, that means that they ratified the decision that I made, which they approved the decision that I made on their behalf. Now, this is one thing that I hear often, and I'm sure you all have heard it too. Sometimes when people die, people are under the assumption that, well, Mama, she had power over attorney of Ray, so she hold a power of attorney, so she can do whatever she want to do. No, she cannot, because power of attorney, it expires when the person dies. Healthcare power of attorney. It is similar to a general power of attorney, but it's regarding healthcare decisions. Basically, if you're in the hospital and you need care, you're unable to act for yourself or make those decisions, you have the healthcare power of attorney to give to doctors to be able to make those decisions for you in case you can't. Then we have a living will. So how many of y'all have heard of the term do not resuscitate or DNR? And then every time you're in the hospital, they ask you, do you want a living will or do you have one? Would you like to execute one now? Well, the purpose of that is if you are deemed to be terminal, incurable, and there's like absolutely nothing they can do for you, so your death is inevitable, you have a living will that can instruct doctors and medical professionals to, one, either give you life-sustaining procedures, like they can give you nutrition intravenously, give you hydration, or they could just withhold. So they could just withhold and then do not resuscitate, or they can give you those things so that you can preserve your life for as long as possible. Because, you never know what's going to happen. The doctor could say, and this is just a personal story because I can only give y'all personal background information. Okay, so I was maybe 11 or 12, and my dad was in the hospital. And he was in the hospital for 2 weeks. And they were like, well, we're just going to let him go, whatever, like that. And while I was just a little young thing, I couldn't really make all the decisions. But eventually, he woke up on his own and he was okay. Now, just think of the fact that if we would have had a living will in place that withdrew all necessary life-sustaining procedures, then that means that, I wouldn't have had more time with him. They would have just let him go. So I say all that to say because, we're also in a church setting. God has the final say. I always tell my clients to think twice when they do this living will in terms of being DNR, because you just never know what's going to happen. And God is still out here performing miracles. All right, so we covered that. One thing I want to say about these power of attorney. You have to have these executed by a notary, which most attorneys are notaries, right? and 2 competent witnesses. That is the only way that it is valid. Now, if you move to Texas or you move to California, your power of attorney will still hold valid there. And you can have a copy of the power of attorney and it'll still be valid as much as the original is. I often tell people, just as a sidebar, you want to make sure somebody in your family that you trust has a copy of your advance directives, and you might want to have a copy on file at the bank, especially the general power of attorney, so they know that whoever holds that general power of attorney has the right to take care of your bank accounts and things of that nature. So we talked about living wills, so we can go past that slide because I basically want to stay right there. All right, so let's talk about last wills and testaments. We have 2 types of wills in Louisiana. We have the notarial testament, which basically has to be signed in front of a notary, and 2 competent witnesses. And then we have the holographic will, which basically is where the testator or the person who's leaving this will would write down in handwriting. It cannot be typed, in handwriting how they want their assets to be divided, what they want to be done in their demise, and then they would sign it and date it. And that would be considered a valid holographic will. So in Louisiana, if you die without a will, and we're going to talk extensively about that. I have handouts on that. In Louisiana, if you die without a will, it's called an intestate succession. So that means that the general heirship rules would apply. And what I mean by heirship is just basically next of kin, depending on your situation, if you're married or if you're single, if you have children or if you don't have children. And so I always recommend that you do a notarial testament or a holographic testament. Why? Because it just cuts down on all unnecessary drama and confusion. And so I have the handouts that you guys have picked up. Are these going to be available online? Okay, these handouts are also going to be available online for our viewers who are watching. You're going to be able to see the different rules and about probate and succession in Louisiana. So, okay, let's talk about the process of when someone dies. So when someone dies, you call the coroner, you take the body to the funeral home, and what happens at the funeral home is funeral homes often have financing companies that'll fit the bill until the life insurance policy is able to come through the funeral home and a check is able to be cut. So now do you kind of see why it's kind of good for you to have the life insurance policy in effect? Because most funeral homes have funding companies. And if you don't have life insurance, you will be paying out of pocket, which there goes toward why you see many GoFundMe accounts and the plate sales. Nothing's wrong with it, but if you can work smart and not harder, that would be beneficial. And then, so we get to the whole, okay, the funeral is done. What are we going to do with this person's property? They have a car, they have a house, they're married, but they didn't have a will. So what do? Well, we got to do a succession with the court to be able to transfer the property over to the heirs. Now, let's say that they had 5 acres and they had 5 children. 5 acres of community property, meaning 1, they were married, but they had 5 acres of separate property. So the separate property doesn't necessarily go to the spouse. So what happens in the community property context? Okay, we got these 5 acres and they got, let's say, 3 children and a wife. Well, on the separate property, the 5 acres of the separate property, that's easy. Got 3 children, that separate property, 5 acres, it goes to your 3 children. And they split it, it's a third. Each child gets 1/3. Okay, but the community property, what happens with that? Well, the wife has her 1/2, and the husband has his 1/2. But let's say it was a husband that died. So the wife has 1/2, the husband has 1/2. But the children, the 3 children, will get the husband's one half. But the wife would have what we call a usufruct in Louisiana, which means the use and enjoyment of the thing, which means that she can still occupy those 5 acres. She can use and enjoy it. But the only thing that she cannot do is what we call abuses. She cannot encumber, sell, or mortgage the property, because technically she's co-owner and in division with her children. Okay, let's say mama and the children get into a fight. After they have all been placed into possession, well then that's a whole slew of things that have to happen with that. Now we have the context where we got to go through a partition because mama and her children, which they should be able to get along, and let's not talk about if he had like stepchildren, they should be able to get along, but they're not getting along. And so they have to partition those 5 acres. If they can't make a decision and partition it in kind, guess what the court's going to do? Can anybody guess? Sell it. Sell it for the fair market value, and they're going to be able to just take the cash and do whatever. So that's also why it's important to have a will, because you want to be able to keep your property within your family, and people should stop selling grandma's property, because there are 2 things that they are not making anymore in America or in the world. They are not making any more time, so please don't waste people's time. And then they are not making any more land. So acquire as much property as you can and keep it in your family. That's a way to leave a legacy. So that's a takeaway. They're not making no more time and no more land. So you get what community property is. Basically, community property is basically acquired by spouses during a marriage. A separate property is property owned before marriage. Property inherited by one spouse during marriage, or property given to only one of the spouses during marriage. And we talked about usufruct, which is on your document. And so basically, a succession is going to be the process of settling a deceased person's estate and distributing the property to the heirs after the debts are paid. That's another thing. I mean, if the estate of the person has debts, that has to be paid out of whatever the assets are. So let's say somebody's mother's died. Let's say Ray Ray. Ray Ray's mom died, and Ray Ray's mom has a $5 million estate. Let's say she inherited it, and it's her $5 million estate, has a house and all this good stuff. Well, she dies, and with that estate, she has like $2 million worth of debt. I don't know how anybody has $1 million worth of debt, but it's probably possible. But anyway, she has $2 million worth of debt. So that $5 million, just to use numbers, that $5 million estate, all that's in that estate, some of that has to be sold to satisfy that $2 million debt that is owed, because technically your assets minus your liability is your net estate. So 5 minus 2, which means that estate is actually worth $3 million, because she has $2 million worth of debt. So those debts have to be satisfied. Now, let's say if you didn't have that much, sometimes creditors will work with individuals on debts, and sometimes they won't. Oftentimes what I've seen is when a succession is filed, creditors like Capital One or Discover, they may file a proof of claim in the succession. And after the succession is closed, which is called, we get a judgment of possession. After the succession is closed, they'll file a proof of claim. Now, they know that it's likely that this person is not going to pay, these heirs are not going to pay, they have been placed in possession, and they have moved on with their lives. But, they can still come after the heirs in the estate to have those debts satisfied. Now, in the context of a mortgage, well, the heirs basically would have to figure out how they're going to pay that mortgage if the mortgage is still left on the house after a person dies. And this is either in the intestate context or the testate context, because sometimes you can have a house that's been left to someone in a will, but it still is under a mortgage. And a mortgage in Louisiana we would call that a priority lien. And so by being a priority lien, that debt has to be satisfied first after all of the, first because it's a secure creditor. And then you have the unsecured creditors that have to be satisfied. And then if there are tax liens, taxes is a thing too that comes up in estate planning. If you got a tax lien, that definitely has to be paid first. So, you know, in estate planning, you just want to make sure you have your ducks in a row, have the financial backing, which means get you some life insurance. Because the life insurance, let's say you have a $500,000 policy and you only owe $100,000 on your house at your demise. Well, that life insurance policy, $500,000, you leave the benefit. Let's say I left Sam my policy for $500,000, and I owe $100,000 on my house. Well, I trust Sam, so Sam is just going to pay my house off and do whatever else with the insurance policy. So that's another important thing of why you need to have life insurance, why you need to have a will in place, and why you need to have people that you trust to handle your affairs. Now, also, because I didn't have this on here, a will, you'll have an executor on a will, and the executor will be the person who you trust to handle the affairs of your estate. And with a will, you just cut out all this fight and bickering. It's unnecessary. You leaving your property how you want to do it. You, in your will, you can even tell your family how you want your funeral to be done. Either I want to be cremated, or I want to be buried traditionally, or I want to donate my body to science. You can tell your family how you want that to be done. Another thing in wills that I want to touch on, because I had to learn this in the practice. In Louisiana, we have what we call independent executorship and independent administration. When you get your will done, whoever you talk to as a notary, what these courts and judges are requiring right now, they are requiring that if the will does not say this could be an independent administration or it could be an independent executorship, that executor is going to have to ask the court to do everything, like sell property, make these decisions on behalf of the estate, permission to do all of this other stuff, which independent administration and independent executorship, you don't really have to do all of that. And when I say independent administration, I mean the person is administering the estate and settling the estate to satisfy the debt so that everybody could be placed in possession the way the testator wanted or the way the law requires. Now, if your will ends up, if you have a will and it doesn't say anything about independent administration or independent executorship, then what you can do is you can always have that will modified or redone, and you can provide for that. Or if, let's say, you've never modified it or anything like that, what will happen is you can ask for independent administration, or that person who's the executor can ask for independent administration. But guess what they have to do? They have to get permission of all the heirs. All the heirs. So if you got 3 children, let's say I have 3 children, and I'm leaving my estate. I'm gonna use Erica this time. I'm leaving my estate to Erica to handle as my executor. Well, Erica's gonna have to get permission of my 3 children to do an independent administration, because those are my living heirs, for her to be able to act without permission of the court. Now, let me tell you something about administration and executorship. You need to make sure that this person is on their P's and Q's, because I have seen contexts where you have executors and administrators of successions who are not on their P's and Q's, and basically they have a fiduciary duty. When I say a fiduciary duty, they have a duty of loyalty and a duty of trust to handle that estate how it should be handled in the right way, and to keep those heirs informed. And so if that doesn't happen, you can also ask for them to be removed in the context of court. So I say all of this to say, if you want to cut down on convolution and all of that, just get a will. Do you need a will? Yes. But some people have this mindset, oh, I don't have nothing, so I don't need a will. You may not have nothing today, but that don't mean you're not going to have nothing tomorrow. You know, I could run into, I could go win something or win a prize. Maybe they have a $500,000 prize and I won $500,000. Well, that's something. I can go buy me a house and buy me a Mercedes and then have me a nice little savings to sit on. And then I'll take it to my financial advisor, because remember, I just came into this, tell her to go flip that money and invest it, and then I'm a millionaire. So I'm saying in the context, just because you may not have anything right now that you think a will would be necessary for, you don't know that, because you don't know what tomorrow is going to bring. And a will can do other things too. You can name a guardian for your minor children in the will. You can create trust for your children, your grandchildren. If you have special needs heirs, which we call forced heirs, they're under 23 or they have a disability, you can create trust for them. You can make provisions for your estate taxes and for larger estates. And again, you can name the executor to collect your assets of the state, pay any bills, and distribute your estate to your heirs. If all of this is not important to you, then you don't need a will, but hey, you never know what tomorrow is going to bring, so you need to consider having a will. It doesn't even matter what. Look, you can have a will that says, I leave all of my property that I died possessed with to Billy Bob. At least you made a plan for your assets, whether you have assets now or whether you don't. Okay, so also on my little chart, I gave you guys a little worksheet. I gave you guys this document about small successions, because sometimes attorney fees are high and they cost. In Louisiana, if your estate is $125,000 or less, you can file a small succession affidavit and have a notary complete that, and you can file it and be placed in possession of the property. Your heirs could be placed in possession of your property. The small succession has the same effect as an intestate succession, and it also applies if the decedent died at least 20 years prior to the date of filing of the small succession leaving property in Louisiana. So that is an option. I really do not like small succession affidavits. I just prefer to go through the court, and I tell clients this. I don't subscribe to it. People can do it if they want. I just think it causes more confusion than it needs to cause. Even though it's a cost-effective procedural device, it's really easier, because see, like banks will want to see a judgment of possession on how property is supposed to be divided. And I guess maybe a small affidavit would do it because it's recorded in a mortgage record, just like a judgment of possession would be to make the proper transfer of the property. But really and truly, I think if you go through the court and get your judgment of possession, that judgment has more of an effect and it's more permanent to me than an affidavit. But people have their own preferences of doing things. But I just feel like people have to realize that their greatest investments are in themselves. And so if you carry that mantra, your heirs or whoever you put in charge of your estate would carry, or they should carry that mantra as well, to keep your investments that you made in yourselves protected. So that's it, and this is just for y'all's education. The small succession affidavit, it is filed in the clerk of courts conveyance records, but so is a judgment of possession after the probate or succession is closed. And so that's all I have on last wills and testament. Unless you guys have questions, I don't think we have any questions. Do we have any questions on those pieces?
Yeah, we have a lot of questions from the audience and online.
Okay,
if we wanna
so let's
started.
get those questions, and then I'll talk about trademarks after we finish those questions.
Okay.
Good morning.
Good morning.
So my question was about the executor. So does that same person need to be the beneficiary of your life insurance?
They can. So this is one thing I didn't talk about. Life insurance policies and retirement plans and 401ks, they have a built-in beneficiary. So they don't necessarily go through successions because that's already provided for, right? So your beneficiary of your life insurance policy can be your executor. But you know, the life insurance policy is not split like other assets are in the succession. And so unless the beneficiary of the policy is your estate.
Okay, next question.
Hi, good morning. I actually have a few questions, if you don't mind.
Okay.
The first one, I wanted clarification. You mentioned a general power of attorney and a healthcare power of attorney. Can the general power of attorney not serve as the healthcare power of attorney?
Absolutely.
Okay.
Because here's the thing. You may have one person who's more business savvy than the person who's more health savvy. So the general power of attorney doesn't have to be the same person as the healthcare power of attorney is.
Got it. Thank you.
You're welcome.
Can I ask a second question?
Yes.
Okay, cool. I believe you said that a usufruct cannot sell property. Is that correct? Like they can enjoy it, but if they acquire it or they become the usufruct, they're not allowed to sell that property?
Right, because they only have the use and enjoyment of the thing. They're not considered the naked owner of that one half of the okay. So let's do an example here. You have yourself and maybe your husband, okay? Husband passes on, and then you have usufruct over his one half of the estate. Okay, you can sell your one half, but you can't sell his one half, because if y'all have children, only the children can sell his one half, because that would be naked ownership.
But can the children sign it over to the parent?
The children can definitely sign it over to you. So they can sign it over to you in what we call an active donation, or you can buy them out.
Okay, First Lady, you added another question now. I think, well, I'm gonna ask this question and then I'm gonna pass it. So, in the event that it's separate property, can you become a usufruct over that?
That's not really a thing, a context that I've seen.
Okay,
Now, I could be wrong, because I didn't really go through separate property. But separate property, if something happens to you and you have separate property, this is the order by which it's going to go. And it's on the handout. Especially if you die without a will. It's going to go to your children first. If you don't have any children, it'll go to your brothers and sisters with the usufruct to your parents. So let's say, okay, you got 4 or 5 sisters. Your 4 or 5 sisters, they'll be the naked owners of that house, but your parents have the right to use the house. And so your 4 or 5 sisters, they can actually sign that house over to your parents, and your parents will be the owners of it. But if you don't have any brothers or sisters alive or their descendants, because what we do in Louisiana is representation. So if your brother is not alive and you don't have a will, but he has 2 children, his 2 children have the right to inherit. And so that goes to your parents. And if you don't have any parents, it goes to your spouse. If you don't have a spouse, it'll go to any of your other relatives or the nearest relative. And then if you have nobody, because some people do not have anybody, that's a harsh reality, but it's true. It goes to the state. So that's why you need to have a will in place.
Right.
Everything comes back to you need to have a will.
So, first of all, I got to tell you, I've really enjoyed you. I just kind of stepped in, and you've been awesome. Can you
Thank
please
you.
talk to the audience about the possibility of active donation prior to being deceased and the benefits of active donation, especially as it has to do with decreasing the overall value of the estate so we can avoid estate taxes?
Yes. So there are two different types of taxes. If you die before a certain period, you don't have to pay inheritance taxes, but estate taxes are a thing. Some people can, and also too, this goes into like, Medicare and Medicaid. Sometimes, if you have a large estate, you don't apply, you don't qualify for those types of services. Like, let's say you had to be in a nursing home or something like that. And so that's why it's good to have an estate planning way ahead of time, especially if you have to be in a nursing home and things like that, because it could just get really messy. So you can have active donations done before you pass on to decrease the value of the estate. That's what we call an inter vivos donation. And right, it's your property, so you can do what you want to do with it. So you can do an active donation to whoever you want to decrease the property. And that we have two kinds of donation. Inter vivos, meaning while you're alive, and then we have mortis causa, which is basically through the will when you pass on. And so that is beneficial too, because you may have like 3 or 4 houses that are both like worth $200,000 something. Well, you can just donate those out to, and be careful in how you do it, because sometimes they will come back and say, well, you did this with this type of intent or whatever. Somebody always comes up with something. But it's nothing wrong with you doing that. So you definitely can donate your property how you want to donate, especially if you're right here on the cusp and you need to do some things and get your affairs in order, then that's okay. Did I answer the question? Okay.
I have a question for you. So if you are currently exercising power of attorney for someone who's unable to make their own decisions, but they don't have a will in place, do you have the authority to create a will for them as well?
So no. Okay. Reason why is that if they are incompetent as an attorney or a notary, I cannot execute a will. I have to do certain tests and ask certain questions to determine, are you a competent individual that you can make these decisions? So no, and that's why, and everybody doesn't do it like I do, but I'm me and they're them. So so that is why when somebody comes to me talking about they want a will drafted, I sit them down and I say, look, I don't draft your will without drafting your power of attorney, your healthcare power of attorney, and getting you a living will and getting those packages together. I just don't do that because I can't in good faith do that, because that person could lose competency. And then what? They don't have a will in place, or they don't have these power of attorneys in place. And then it goes to the next of kin, and they may not trust Ray.
Another question. If you have an insurance policy through work, do you recommend getting something separate from that in most cases?
Absolutely. I'm glad you asked that question, because here is the thing. The insurance policy at work is just at work. While you're working at that job, you still need to have your own separate insurance policy. And people be talking about costs and stuff like that and expenses. Look, me personally, this is my mantra. I don't think that protecting my assets and my brand and things like that is too expensive. I'm an attorney, and I'll tell you right now, even as an attorney, I used to drive for Uber, and I was working at Kirkland's just to make ends meet. So I don't mind working. Look, I will go to work a night job at a retail store if that means that I got to pay for life insurance or to protect what I have. I'll do what I have to do, okay? So yeah, you need to have the life insurance policy separate. And then these work life insurance policies, they're not insuring you for like $325,000, and they're not looking at the whole estate like a financial planner or insurance agent would. They're giving you basically a general burial policy for $25,000, so that in the event that you die on their job, then you recover.
Okay. Online question from Victoria. Do my children have to be 18 in order to name them as a beneficiary?
No, they don't. I have a godson, and I have some nieces and nephews out here, and I have them as little riders on my policy.
Okay. Mhm.
Yes. So if you name your estate as your beneficiary, that's the only context in which the life insurance policy is going to have to go through succession. Because if you name the estate as the beneficiary, then whoever's in your estate, the heirs, especially if you don't have a will, then they will inherit that policy in equal portion. So let's talk about in the context that you do have a will and you have your estate inherited. Basically, that life insurance policy, as I appreciate it, will be considered a residual of your estate or the balance of the estate because you didn't leave a general legacy. Like, for instance, somebody may have, one more thing I want to say. I'm glad you said this. If you are a person of the Divine Nine, please consider getting a will and put in your will where you want your Divine Nine paraphernalia to go. Okay? I'm a Delta, and I've done wills for other sorority sisters, and I have made them put in their will where they wanted their Delta paraphernalia to go. It could go to the chapter that they came from, a graduate chapter, or another Delta. But you need to make provisions for that. So segue back to the life insurance piece. That would be considered the residual of your estate because it's not a specific or particular legacy or bequest. You got some people that may have their real property, which they want that to go to one person. Or they may have a collection of pearls, a collection of records or instruments, or they may have like 3 toy poodles that they want to go to someone. You know, those are what we call particular legacies and specific legacies that give a defined item or collection of who they want that to go to. But the general of the state, the general or the residual balance of the estate, it'll go to another person, right? So that life insurance policy would probably be considered the residual of the estate, and then it will go to that person. So all that to say, don't leave your life insurance policy to your estate.
Okay, quick question about trust. I know you said you were gonna get to that. So, and then when she said about the beneficiary being under 18, so if Juju is the beneficiary of my policies and she's a minor.
And she's a minor, then what happens is you would need to make a provision for her to have a tutor, what we call a tutor or a guardian that can, because now it's her estate, it's hers. So it'll be her estate, but somebody who could oversee her estate for you.
Okay.
Yeah.
Is that where a trust would come in? Like, could you talk a little bit about the benefits of a trust? And how
So I can and I can't. Because I don't necessarily deal with trust, because I think a will can do what a trust can do, but it really is, they are different schemes. With trust, you have a revocable trust and you have an irrevocable trust. And so those trusts, they all have a beneficiary embedded in them. And then they have the settlor is normally the testator or the person who's creating the trust. And then you have the beneficiaries. And the trust basically operates to where the beneficiary may get a little sum every month or, you know, that kind of thing. The trusts have different schemes, and so I don't really feel that qualified to talk on trust. It is an option, but it can do the same thing as a will, because see, the thing is, you can put a trust in a testament. You can create a trust in your testament and it's formed. You can get with a financial planner to make sure that's formed correctly with your funds and stuff. But mainly, from what, as I appreciated, the person who is the beneficiary, they'll get their little monthly payment from that trust until the trust is exhausted.
I have one question. Well, more so a question statement. I have a friend who tragically passed away, and she left her child as the beneficiary and not her husband for whatever reason. So now he's in a situation where anytime he wants to get anything for the child, he has to petition the court. So is that something that parents need to think about when they do list minor children? I know they don't expect to expire prior to their child turning 18, but in the event that it happens, can you speak on that?
Yes, because that child is still considered a minor, and even though they have a tutor, that most times courts will require that the funds that they have be placed into an interest-bearing account, and the kid would not have access to it until they are 18. And the tutor would have to make those decisions and petition the court, especially for any kind of major expenses. So yeah, I do think it's right for people to think about that beforehand. Just make sure you have all of that in place, because if you have a tutor for your child in your will, that's automatically going to tip the court off that, hey, a tutorship proceeding needs to go forward, and that this child is going to have X amount in her estate. So, yeah.
I have a question. Some of the things you've talked about with the will make me think that I need to do some modifications.
Okay.
And my question is, what happens if you're not ill, but you become ill? How long what period of time should you have made modifications when it comes to Social Security or hospitalization?
As long as you're competent, you can make those modifications, as long as it wasn't done under duress or coercion. Because see, what happens is Ray and Pookie and them might get offended with you, and they'll say that your favorite daughter coerced you. Susie coerced Mama to change that will, and she knew Mama was sick, and Mama is not. I've seen it. That's it. As long as you're competent, and that notary or that person, that attorney who's drafting that for you, can ascertain that, then that's fine. It's totally fine. And I've had instances where, when I first started out, one of my first cases was a guy who was in the hospital, and he wanted to get a will and stuff in place. But he was still competent, so it was still valid.
I don't have a question. I just want to make a statement that it's also important to share the will with your family or whoever is in it, so they'll know what's in place. So once you do pass, it won't be any contesting, or they won't have any problems. Well, they may still have problems with it, but they'll know that that was truly what that person wanted if they share it with them while they're still alive and competent.
Yes, that's true. You should do that. I will say, for me, because I've had to bury a parent and go through the whole funeral process and dealing with everybody. But the thing was, I was next of kin. And so my dad had 4 children. I was the oldest. I did everything for my dad. I handled his affairs and everything like that. And one of the things I did make him put in place was a power of attorney, a healthcare power of attorney. Now, he really wasn't able to do the will because we didn't expect him to die. I didn't expect him to die, but he didn't have a really large estate. And so what he did was, in the hospital while he was still competent, he had a family meeting with his siblings and his dad and his parents and said, look, my daughter is taking care of all of my affairs. Whatever she says is what goes if something happens to me. So it's just that is a good thing that you pointed out. talk to someone in your family so that they'll know what you want. But also have it in writing. If it's not in writing, it means nothing.
Is it true you have to include every child in the will?
Absolutely not.
Oh.
Okay, let me tell you why.
Okay.
Because, you know, sometimes the pop-up outside children come up and say, that was my dad, that was my, you know, it happens, and then you like,
Yeah.
what's going on?
Yeah.
So here's the thing. As a person who has a will, if you have children, you can disinherit anyone you want as long as they're not a forced heir, meaning they are not under the age of 24, because the reason why we have forced heirs in Louisiana that are, you know, age 24 and under is because of, you know, the benefits in the state that the state really doesn't want to take care of those kids. You need to provide provisions for them to be taken care of, especially if you got a wealthy estate. So you can disinherit anyone except a forced heir. Now, the other context of a forced heir is someone who's disabled or has mental incapabilities. So you can disinherit anyone you want. And they can't contest it unless it was like something where, again, the Pookie and Ray Ray context and Susie context, Susie was coercing mama to do this and do that, or this was done under duress and all that kind of thing like that. That's the only way that somebody can contest that. But when you have a will, actually, if your children are cutting up and you're not a fan of them at this point, you don't have to leave them anything. They're grown. They have to do what they got to do for themselves. Now, is it right? Probably. Is it morally right? Probably not. But you might need to leave them a little something. Maybe leave them $10,000 or something like that. But you don't have to leave stuff to the kids. Now, should you provide for your kids and leave a legacy? Yes, I do. All of them, even if it's, you know, outside kids or anything like that. Because, I mean, life happens, but you don't necessarily have to, because parents and children fall out. But my Aunt Dot, she used to tell me this all the time. It is true. Teeth and tongue do fall out, but y'all get back right. So, you know, that is what it is. And sometimes you'll have the context where there was one will that was done where Pookie was left out. And then there's another will after that was done and Pookie was put back in.
Oh,
so
wow.
which will is valid?
Yeah. I have a question.
Which one is valid?
Yeah, the last one, right?
It's gonna have to go to the court, but probably the last one. But Pookie may start some drama, or Ray Ray may start some drama with Pookie and be like, no, man, you can't, you're not getting anything. I don't care if that will put you in there. Well, because I got this will that says she wasn't leaving you anything. And you coerced her to do this, and you know y'all wasn't tight like that. So that's expenses to an attorney to fight that out for a result that probably the last will takes precedent because it was the latest version.
Yeah.
I was going to say, but if there is no will in place, then all the children have the right to get what they think is theirs, protest for whatever they think is theirs.
That's called intestate. They didn't write a will. So everybody gets to inherit. And then if you do something that was wild and you didn't provide for these other children and you knew there were other children and they come back on you to reopen that succession, you might be in some trouble as an heir. You might have to pay them.
Wow.
Yeah, because my family did one, and they actually had to make sure that every child was included and knew what was going on, because they said if you sell the property and another child pop up, then this whole sale could be invalid, and whoever you sold it to may have to get out. It can cause a lot of problems.
That's absolutely right. And here's the other thing. Let's say you had a brother or sister that's deceased, and you knew they had some children.
Oh.
And there's no will. You better include them.
Well, it's 12, and I have the last question. What if you have a business with an account, and you pass? Who does that go to?
Ye-
Or should you put somebody on the account, or put it in the will?
Both. Put the business in the will and put somebody else on the account. Most times businesses are LLCs.
Yeah.
If you don't make provisions for where the LLC goes, or who is it transferred to,
Right.
it's gonna have to be dissolved, and so will the accounts and everything. So,
But will it
and
automatically go
it'll have
to
to
the children?
it'll have to go through whoever is on that LLC. Or if it's just a person, it'll go through the children. But that's why you need to make the provisions for where everything goes.
Okay.
Yeah, because that would have to go through a whole process of liquidation and
Right.
everything.
Is that included with outside property too?
Yes,
Okay.
yes, yes.
Okay.
Especially if the LLC owns it.
Yeah. Okay. All right. All
So-
right. Well,
I got to get to trademarks.
oh, we got trademarks, yes.
All right. So okay, guys. So if you guys saw that little R on my name, that means that I is a registered trademark. So let's go to the next slide. This is a quote. Wait, go back. I want to read that quote. This is a quote that says, "Immortality is to live your life doing good things and leaving your mark behind," by Brandon Lee. So just leave your mark behind. It's something you need to do. Protect your brands, protect your assets. Okay, let's go to the next slide. Okay, trademarks. So I really like intellectual property, trademarks, and copyrights and things like that. Do I have any writers in here, fellow writers, fellow poets, and stuff like that? Maybe I have some out there. If you have some writings and things that you have, you might want to get that copyright with the Copyright Office. But if you have a business and you have a brand, you need to protect your brand. And one way to do that, well, the best way to do that is through the act of doing trademarks. So let's talk about trademarks. A trademark is to federally protect your brand. You can protect logos, and you can protect slogans. The key thing is people think that just because they have an LLC or anything like that in a state that their brand is protected. It is not, because you can have the same name as someone in Texas, and they file a federal trademark, and you are technically infringing upon their mark, and they could come after you for profits that you have made if they feel that you are a bona fide infringer, because they trademarked the name first. So, you may there's a legal presumption of the ownership of the mark. And basically, when you do trademarks, it's putting the public on notice of the ownership of the mark. Your mark is listed in the United States Trademark and Patent Office database. The possibilities are endless. You can record your mark's registration with U.S. Customs and Border Protection. You can bring actions on behalf of your brand in federal court. And you can even have foreign trademarks based off of your brand if you want to. And so your brand is the single most important investment you can make in your business. That's what Steve Forbes said. And look at Steve Forbes. Forbes, right? So I always tell people, protect your brand. If you're out here using particular brands in certain areas of commerce, because there are 45 classes in which you can trademark a brand. And so you need to really consider doing that, because it's not enough for you to just have your LLCs. There was a case, I believe it's a Fossil case in 2020, where they saw that there was an infringer on, I guess, one of their brands and products that was a registered trademark. And so what happened was they were able to stop this person and take their products. Now, let's say you have a brand and you've been using your brand for years, but somebody else went and trademarked it. you can move for cancellation of that mark, or you can, in the context, you can ask for a coexistence agreement. And that's necessarily, it doesn't necessarily mean that the USPTO is going to agree with the coexistence, but at least you tried, and sometimes you may have to rebrand. So all that to say, my entrepreneurs out there, because I know women, we are the highest rate of, especially black women, are the highest rate of growing entrepreneurs in this country. Make sure that if you have a creative idea or, you know, your brand, make sure that name is, you're able to use that name first. And that's why you want to get with an intellectual property attorney to run a comprehensive search, to do that, to make sure that your name is, your brand is able to be, you know, out here in commerce. And then you want to trademark that brand as well to protect it. Because I'll tell you about Attorney Southern Belle. I have been using that name since 2016. I was working at the courthouse, and I know y'all can tell I got like this southern drawl or whatever. And so it's really bad. Y'all hear it, but I don't hear it. But anyways, it's really bad, right? So they started calling me Attorney Southern Belle because they're like, well, you talk like this, but you are a force to be reckoned with because you be commanding the room. And I do. So somebody was on this app, I think y'all heard of it, Clubhouse, and she said she was a Southern Belle attorney for California. And I said, no, she not. And so I went and trademarked my brand because I've been doing this for 2016, and I don't want anybody embarking on that brand and household name. So that's what I did. I trademarked it, and now it's registered. So if somebody is using my pictures out there without my permission, I'll tell them I can send a cease and desist letter to tell you take it down. If somebody is out here using my brand without my permission, I can send a cease and desist letter and tell them to stop, or I'll pursue a legal action against them. And some people's names in and of itself are brands because of what they do, whether like if they're a speaker or a celebrity or something like that. I feel like everybody is a brand out here. Now, not to say that everything needs to be trademarked, but if you're out here having a business and it's really unique and it's getting traction on a level that you never imagined, then you need to do that. Wait, 2 minutes? I got 2 minutes? Oh.
Someone text me a question. Hold
Okay.
on. Wait, what? If a parent passes away whom have kids and the siblings of the parent take the estate because there was no will, can the children get an attorney to redeem those estates?
Yes.
Yes.
Wait.
Read it again?
Read it again.
Okay, question. If a parent passes away who have kids and the siblings of the parent take the estates because there was no will, can the children get an attorney to redeem those estates?
Yes, because those siblings lied to the court. Perjury.
Oh. Yes, Marge. Yes, Marge.
Hello, I had a question regarding trademarks. I'm sorry, right? I went to YouTube University, so I guess they always tell you to get the LLC and then get the trademark. And so I got an LLC for a business, and then I tried to get the name trademark, but the name was already trademarked in the same class. So I just got a new LLC and got it trademarked. So if I want to start another business, do you advise to get the trademark cleared and then get the LLC, or get the LLC first, or does it really matter?
Sometimes it doesn't really matter. So the LLC context, you don't necessarily have to have an LLC to operate a business, but it's preferred, and most times the LLC will own the trademark. Now, you said that the LLC, your name of your LLC the name of it was already trademarked, right?
It was already trademarked in the same class of goods.
Yeah, and so USPTO would deny that and said likelihood of confusion because same class, same mark. So you had to rebrand, right? So did you already put your application in?
Oh yes, glory to God, I got it already. I didn't put my application in, but I went to an attorney and they checked it before we went further with it. So they stopped it, and I was able to rebrand and just change a few words, and then put it in, still in the same class. So I was able to avoid
So
that.
that's how it would work. That's exactly what you needed to do. But you don't necessarily have to do it that way, but that is a preferred way. Yeah.
Thank you.
Any other questions? Any other questions? All right, come on, let's give it up for Attorney Southern Belle, ReAzalia Allen. Thank you so much for your time. This was so informative.
Thank you for having me.
This was much needed. We have to go back to the drawing board. I need that trademark. So her information is in the chat, you guys. If you want to contact Attorney ReAzalia Allen, please do so. This was so much information, and I'm sure someone missed something or overlooked something or have some more questions. Please reach out to her. She is family, even though she's a Delta. Amen. Before we leave, I want to give some announcements. We have some changes to our Women's Ministry Month. Thank you so much for dropping off your toiletries. We do have a bin in the foyer. We're still accepting those toiletries. So thank you, the women and men of Safe Domestic Violence Shelter. Greatly appreciate it. So please continue to do so. We will be accepting until next Sunday. If you want to sow into our community service project, you can text CoverGirl, a space and the amount, to 28950 if you would like to donate to our community service project. Again, this March 14th through 18th, we have our Black Women Do Workout. Okay, yes, we do. So we have a social media challenge that's going to go forth. It's going to roll out this coming Sunday. So I'm excited about this. At 10 a.m., you're going to know what you have to do for the week, and we're going to post those videos to social media. And then Women's Day has changed. There was a time discrepancy with Bishop, and so we're moving Women's Day to March 20th, a week ahead. And Bishop will speak to God's cover girls. We even thank the men that snuck up in here on today and asked their questions. You are greatly appreciated. We're going to close out in prayer. Thanks again to Attorney Southern Belle for all of the wealth of knowledge that you shared with us on today. Father God, in the name of Jesus, we come saying thank you, God. Thank you for what has taken place on today. I hope that something is said on today touch the hearts of your people so that we can do what is needed for your kingdom, for our families, for our children, God. We thank you for our online viewers. We ask that you would meet the needs of the people. In Jesus' name that we pray. Amen. Amen. Hallelujah.